Good morning. How's everybody doing today? Thumbs up? I got quiet, so I'm just gonna assume there's secret thumbs up that I don't see. Well, good morning. Today is Tuesday, May 12th. We have a fairly sizable docket this morning. However, only 4 cases are scheduled to argue from today's docket. So the first 2 cases that I'll be calling are not scheduled to argue. And then the third is scheduled to argue. At that point, if attorneys can please identify themselves and their readiness to proceed. So the first case we have is case number C20396, State of Ohio versus Anthony Mataris. And that case is submitted on the briefs. Then we have C250555, State of Ohio versus Mark Durgan, also submitted. Then the third case, C250536, State of Ohio versus Ulysses Irby.
Laura Peters on behalf of the appellant, Ulysses Irby, ready to proceed.
Good morning.
Sean Hill on behalf of LE State of Ohio, ready to proceed.
Good morning. All right, the fourth case we have is C250629. This is also scheduled to argue, State of Ohio versus Alyssa Gardner.
Josh Thompson on behalf of Ms. Gardner, ready to proceed.
Good morning.
Good morning.
Nye on behalf of the state, ready to proceed.
Good morning. Next case we have is cases C250545, 546, 547, In re DD.
And Jessica Moss as well, on behalf of the
Okay, is one of you will be arguing? Okay, all right, thank you.
Judy Black for the state, ready to proceed.
Good morning. All right, then we have, this is a case that's submitted. It is case number C250582, Van Roberts LLC versus Michael Griffin. The following case is also submitted, C250584, State of Ohio versus Sarah Pitts. And then the last case, we will actually be switching judges, and we will have Judge Kraus in lieu of Judge Moore. And that is case number C250573, Erica Dunson, Administrator versus Springfield Township et al. All righty. Yes. Oh, yes.
You want
Yes.
Springfield Township, State of Timothy Unwin, and Rick Lyon, Katie Barbier, we're ready to proceed.
Good morning.
Good morning, Robert Gresham, and I'm Rucker on behalf of the state of William Dunson. I'm ready to proceed.
Okay, thank you. I was on such a roll of submitted briefs. All righty, so we'll start off with State of Ohio versus Ulysses Irby. Good morning.
Good morning, Your Honors. Laura Peters on behalf of appellant Ulysses Irby. I'd like to reserve 4 minutes for rebuttal.
Okay, thank you.
May it please the court, this case presents one simple question before this court, and that is whether Mr. Irby had a continuing obligation to register in Ohio, and that would be based on a choice of whether or not there's a choice of law provision contained in former RC Chapter 2950. In October 2002, Mr. Irby was convicted of a sexually oriented offense in Minnesota. At the time, he was required to register for a period of 10 years. However, due to a series of events between probation violations, committing of other criminal offenses, Minnesota has unique provisions in which the clock restarts for every period of incarceration, and it additionally adds 5 years for any conviction for failure to register.
And this is based on Minnesota
That's based
law.
on Minnesota law.
Not
I can
Ohio law.
cite this, I mean, the provisions are cited in my brief, but I can tell them what.
That's okay.
So ultimately, in 2017, Mr. Irby's registration period after he was last released from incarceration had extended until 2037. In April of 2021, Mr. Irby moved permanently to Ohio.
Now, before moving, I think he had a period of incarceration.
Correct, Your
Okay.
Honor.
So your calculation takes into account those moments, any stays, anything that went into the calculus of his
Correct.
registration period.
Minnesota has a similar provision that the time any offender spends while incarcerated doesn't count towards compliance. But it also has the unique provision that it requires a continuous 10-year period of registration, in Mr. Irby's case, or a continuous period of registration, so that any period where he was, so there were several times where he was incarcerated for like a probation violation. He was also incarcerated for a theft offense. Those also restarted his registration clock. So even though that they were not, he never committed a new sex offense. Let's be clear about that. So the last calculation that we have from the record submitted from Minnesota was that his time was going to start again on March 10th of 2017 and continue until, or I'm sorry, March 11th until March 10th of 2037.
So would you characterize Minnesota as tolling plus, in the sense that it's like, it has a tolling provision, but it also seems to revert back?
I would, so it's a new clock. It just resets the clock anytime the defendant is incarcerated. So the release from incarceration starts a new clock. So they require.
New clock for a total continuous run of 10 years?
Yes, a total continuous run.
So theoretically, if he had stayed completely clean from any Minnesota violations, his time would have been up in
2012, if he had, in October of 2012, if he had stayed completely without probation violations or new offenses.
I'm sorry, just to clarify in my mind, it starts back to zero if he has a probation violation, or does it stop where it left off and picks up when he gets out?
So the probation violations that he had resulted in incarcerations, according to the Minnesota, the documents that we got from Minnesota.
Right.
So because of the incarceration, the Minnesota annotated statute 243.166 subdivision 6C says upon the release of incarceration, the clock resets
To zero?
to zero.
Okay, thank you.
So even though he had substantial times between that where he had been in compliance for 2 years, 1.5 years, between any of these probation violations or new offenses, Minnesota doesn't give him credit for any of that time.
So it's not even like tolling. It's like do not pass go, do not collect.
Correct. So the harsh provisions in Minnesota, however, don't apply in Ohio. And that is because former 2950.04 says that when you move into Ohio, under A3A, there's a duty to register if you are currently have a duty to register and there's a substantially equivalent Ohio offense. So when Mr. Irby moved to Ohio, he did have a duty to register under Minnesota law. So that's the first step to the question, and we know that.
There's no issue as to whether there's a substantial similar offense.
No, we didn't raise that below. The only reason why I mention it is because if his offense was not substantially similar to an Ohio offense, then there would be no duty to register, even though he had a duty to register.
Exactly, right.
And I use that to show that there is no choice of law provision that says Minnesota or the state of incarceration law applies, because Ohio will look at it and see whether we want this offender to register in Ohio, and there's two requirements. Is currently registering, and is there substantially similar? And if that's the case, then you go to 2950.06B2, and that says for this type of offense, it's an annual registration. And then .07A4 of that says that the date begins when they move to Ohio. And then further down, 2950.07B3 says that period is for 10 years. And then,
So the 10 years is governed by Ohio law. It has nothing to do with Minnesota and the 10 years that, what you had
Correct.
described of the calculus of what
Correct.
takes place in
so the
Minnesota.
date that he moved, I believe it was mid-April. I did not write down the exact date, but it was April of 2021. So it would be 10 years from that date under the Ohio statute. And then there's also the provision that 2950.07E says that he's entitled to credit for any time that he complied with registration requirements.
Does
So-
it indicate that it's mandatory that he gets the credit, or do you think it requires him to actually apply for the credit?
The credit, I would say, is mandatory because it says the sheriff shall grant credit. Now, the provision of whether or not he has to apply for it, it says that the defendant may. And the Ninth District in Eager versus State indicated that there is no mandatory provision on the defendant to apply for credit. Nevertheless, but when you're talking about charging him with a criminal offense in Ohio for failure to register, you should examine whether or not there is a duty for him to register.
So you're basically asking us to apply the statutory language and to also adopt Ninth District Eager case.
Yes, Your Honor.
Can I ask a question about the credit? You
Sure.
described under Minnesota law that if there's incarceration, then his reporting time is wiped clean. So because he was incarcerated, isn't all the time that he registered in Minnesota now wiped off the books? So what credit would he have if he is not getting credit for that time in Minnesota?
He's not getting credit under Minnesota law, but Ohio law says that he gets credit for any time that he was in compliance with the registration requirements. And we know, based on the records, that, and there's no dispute, the state didn't take issue with the calculation and ultimately sort of conceded that Mr. Irby has registered for over 10 years. So those registration periods don't go away. Ohio doesn't have a similar provision that says, well, we're going to restart the clock.
But he has to comply with Minnesota law in terms of the registration to get credit.
He has to comply with the registration requirements.
Right. And
And he
those requirements require him to stay out of jail. For him to get credit, he has to stay out of jail.
But Minnesota has a unique provision where it resets the clock. It doesn't negate the fact that he actually registered. He has actually registered, and that's all Ohio law was looking to, is did he register? And
So if he had not moved to Ohio, he would still be subject to Minnesota's law, and he'd still have his time to serve under Minnesota's law.
Correct.
But by moving to Ohio, you contend that that has gone away.
Well, at the time he moved to Ohio, there's still some time that he had to register. So, because he registered for over 1,000 days in Ohio, so there was still a period of time where he was required to register. So it's not like there was no period of time where he was required to register in Ohio. And I'd like to point out, like, in Florida, they have, all their sex offenders are given lifetime registration requirements. When they move to Ohio, that doesn't apply to the offender. Ohio will apply its own.
And which case tells us that about Florida people?
I don't think I cited that, but it's known that Florida has a lifetime registration requirement, and it's similar, and that we still look to Ohio law to determine, like, which case? It's in State versus
Is it Lloyd?
Lloyd. They were looking at the provisions and.
I mean, it's also a little bit about Megan's law, is it not?
Right,
But
right,
state-
because it's, yes.
State versus Lloyd kind of addresses it directly.
Yes. So if the court has no further questions, I'll reserve the remainder of my time. We just ask that this court reverse and grant Mr. Irby's motion to dismiss.
All right, thank you.
Morning, Your Honors.
Morning.
Good morning.
May it please the court, I think setting aside any discussion of what Minnesota law does or does not say, there's a much simpler answer that this court can arrive at, strictly with reference to the language of the statute itself, in this case, 2950-07, and that's basically, the statute says this, okay? So Mr. Irby, regardless of what his registration period was in Minnesota, he moves to Ohio. Under 2950-07B3, by default, he has a 10-year obligation to register. So he moves here in 2021. The sheriff determines that he has to register until 2031. That duty, per 2950-07A4, commenced when he enters the jurisdiction. All good. Looking then to 2950-07E, this is the talk about whether or not he's entitled to credit, right? So 2950-07E creates a mechanism by which a defendant may get credit. The language of the statute is clear. It's permissive. The defendant may apply to the sheriff for credit. Then they have to
Well,
provide.
it's permissive as to whether they are to apply.
I'm sorry?
The language, the May language is about the duty to register, about the registration itself. It's not about the credit, is it?
2950-07E may apply to the sheriff of the county in which the offender or delinquent child resides or temporarily is domiciled for credit against the duty to register for the time that they have complied with the offender registration requirements of another jurisdiction. Then the statute has mandatory language, which is that they shall give credit, but only for time for which the offender provides adequate proof of their compliance with out-of-state requirements. And I don't think there's any dispute that Mr. Irby didn't do that in this case.
He didn't apply,
He didn't apply.
but he could apply.
He could have applied.
Theoretically, he could do it right now.
Theoretically, he could do it right now.
So it seems a bit like a vain act,
A vain act.
in the sense that we already know all the facts and everybody knows what happened in Minnesota, and the sheriff is statutorily obligated to grant the time.
But the question becomes whether the sheriff would have known that absent what we've litigated through this case, right? I'm not sure where that exhibit, from my recollection, I don't know where
Well,
that
isn't the
exhibit-
lack of the sheriff knowing that what landed this case in front of us?
Correct.
So in other words, because he didn't take on the choice of registering so that it would be clear as to whether his duty to register had already been fulfilled or not,
Correct.
then he winds up being charged.
But it's pretty clear that the statute, by its plain language, whether you agree with that
So
or
are
not.
you saying that he would not be able to establish it in front of the court then?
Well, I'm saying that's not what the statute provides for you. It provides a pretty clear procedural mechanism by which an offender can get credit. First, they have to apply to a sheriff, and then they have to provide adequate proof of compliance with out-of-state registration. Then if there's any lingering dispute, there's an appeal.
Well, it says
to the
he
Court of
may
Common Pleas.
apply to the sheriff, and then he must provide adequate proof. So you haven't really contested whether he provided adequate proof in front of the trial court, have you?
I believe that exhibit may have come from us, showing
Okay.
when he was registered and when he wasn't. I mean, obviously, it was established by the record below.
So basically, the heart of your issue is where he is to present that proof.
Right, and the
Okay.
language of the statute is crystal clear on this. There's a procedural mechanism. I mean, it's laid out in plain language that first he has to apply to the sheriff, say, hey, by the way, I've complied with.
Okay. What's your position on Ninth District and their determination under Eager v. State?
Well, so the thing that's interesting about Eager is my contention would be that it flips the statutory language on its head, because while they purport not to read anything into the statute that isn't there, they're basically creating an implicit requirement that the onus is now on the state to provide mandatory credit and to determine what credit the applicant or the offender is entitled to, which is the exact opposite of what the statute says. The statute says that it's on the defendant to show proof to the sheriff, and then if there's proof, obviously we litigate it. But basically, they're saying that the Ninth District is saying that the credit is automatic, and that's not what the statute says. It says that the default is that 10-year registration period, and then the offender may apply for credit. which
Well,
is
I'm
not what
assuming it's
happened.
automatic with the adequate proof. There still needs to be adequate proof, no?
Well, there needs to be, it becomes automatic once the applicant provides adequate proof. So.
Well, aren't they kind of raising it almost as like an affirmative defense to the new criminal charge here? Like, he could have done all of this theoretically,
He could have.
administratively, without even a criminal charge, and then avoided the criminal
He
charge.
could have, but he didn't, and here we are, is what I'm saying.
Should it be allowed as an affirmative defense?
I don't think there's anything in the statute that provides for that. I'm going strictly by what the statute says here. So I think the answer at this point would be for Mr. Irby to apply to have his, obviously, since the cat's out of the bag, to have his registration terminated and to have his.
That wouldn't help him with his current criminal conviction, though.
No, but if the legislature intended for the procedure to be that he was automatically entitled to credit, or that it would be an affirmative defense to this charge, they would have put that in the statute, and yet they didn't.
But if you're talking about statutory interpretation, if the legislature intended for the only means for the credit to be given is by registering then it would, instead of may, it would have said shall, would it not?
I'm sorry, could you repeat the question?
Okay, so the language says that that he can apply, he may apply, right?
Right.
So wouldn't the legislature have used the language shall rather than may? And that would support your position stronger?
I don't agree with that position. I think the way that the scheme is set up, whether you agree with this or not, the legislature clearly intended that the default position would be 10 years, and then if the applicant or offender wanted to have that credit, they could then apply for it. It's permissive to the offender. If the legislature intended for the offender to automatically be entitled to credit. I
Well, it's
think
not
they would-
automatic, it's with presentation,
Right,
right?
right. But isn't that what you're asking me? If you're saying that the offender shall apply for credit,
Right, if the language was the offender shall, then that would be supportive of that that's the only mechanism in which the offender can present the proof of registration and be provided with acknowledgement of the credit.
so I'm getting a little mixed up here. I think it's permissive to the offender. Basically, if the offender wants that credit, they may apply for it. But if you read Eager, what they're saying is that the opposite is true. They're essentially saying that the offender is automatically entitled to credit, which is simply not in the statute. So I think that supports my position for going by strict statutory interpretation.
So between 2002 and when he came to Ohio, did he have any other crimes that would qualify as crimes that would require registration?
I didn't parse the record closely enough to make that determination. I don't believe so from my recollection, but I could be mistaken.
So effectively, under your argument, he'd have a 29-year requirement going back?
Under Minnesota law, I think my argument here today would be he has a 10-year obligation subject to any credit time to which he's entitled, which he never applied for. So here we are. It's kind of a bizarre result, as that may seem. Sometimes the law creates bizarre results. So unless the court has any additional questions, I will submit on that.
Thank you.
Thank you.
What I didn't hear, Your Honors, was any argument that Minnesota law applies. So I think then that the question is just referencing Ohio law, and that it's a 10-year period, and that Ohio law allows for credit for any time that Mr. Irby spent registering.
But the state's argument is almost like a jurisdictional argument, that he has an administrative process. He didn't avail himself of the administrative process. Having failed to avail himself, he cannot get credit because it is not due.
A similar argument was made in Eager versus State, and the Ninth District said that they weren't going to read into the statute an implicit forfeiture of the credit because the defendant, or because Mr. Eager did not apply for credit. So yes, there is still requirement for Mr. Irby to have shown that he spent the chunk of time that he wants credit for, that he submit adequate proof of that. And that was done in this case, and there's no question that Mr. Irby has registered for over 10 years. So because the statute itself does not impose any penalty on Mr. Irby and actually makes it permissive for him to apply for credit, the fact that he's now seeking to have this credit applied in his criminal case, because it's, in other words, it would be unconstitutional for him to be convicted of an offense where he had no duty to register, and that's from State versus Palmer. So based on that, if he has no duty to, if he had, there was adequate proof that he has the time for credit, therefore, and the credit shows that by the time that he was charged with failure to register, he had already completed the 10 years. So therefore, we would ask this court to grant or to reverse the trial court and dismiss Mr. Irby.
Thank you. Thank you both for your arguments this morning. We'll take the matter into submission, issue a timely decision. I wish you both a wonderful afternoon. Good morning.
Good morning. I'd like to reserve 4 minutes.
Okay.
May it please the court, counsel. Alyssa Gardner was convicted of violating a protection order based upon prejudicial evidence that the state willfully did not disclose in discovery and the testimony of 2 witnesses who lacked credibility and had a motive to be untruthful. Her conviction should be reversed and remanded for a new trial. The first assignment of error is regarding the discovery violations, and we believe the court abused its discretion by only ordering a short recess where after the state committed Criminal Rule 16 violations. The state failed to disclose Exhibits 5 and 6 in discovery. Exhibit 5 was important because the golfer emoji was used to prove Miss Gardner's identity. And Exhibit 6, although only proffered into evidence, was used by the trial court as evidence of the date in which these offenses took place. And that normally on or about, date is not a crucial issue, but here it has to have taken place after the protection order was in place, so.
And were these exhibits the only source of the information about the golfer emoji and the date of the message?
Golfer emoji, no, but the date, I believe it would have been the only one post, but
Didn't the victim go to the police station when she got the message and explain when she received it?
she did go to the police and and have charges filed, but I don't know that that is necessarily evidence that the messages were sent after the protection order was in place. It's a credibility determination, I suppose.
Right, but my understanding is that she showed up at the police station saying that she got this message after the protective order was issued, and this is in violation of that order.
That may have practically happened. I don't remember if it appeared in the record or not as like testimony that is how it happened. If it did, then ultimately,
Well, let's focus on, you agree the golf emoji had other sources of evidence other than the questionable exhibit?
it did.
And if it had other sources, then that becomes harmless error.
I would say the difference here is that because it came in, the defense then entered in the evidence that had the golfer emojis. And we can't really go back and reconstruct defense strategy before this violation took place. So essentially, the defense entering that evidence may have been solely a result of the Exhibit 5 being allowed into evidence. In other words, we can't really unwind what happened and predict what defense might have done otherwise. So,
I mean, at most, the exhibit simply corroborates the golfer emoji testimony.
Exhibit 5, yes.
So even without Exhibit 5, that testimony would be of record, and the identification of the use of the golfer emoji and the previous contacts on social media, yes?
Well, yes, with the caveat that I don't believe that the golfer emoji would have been corroborated by the state's evidence without Exhibit 5.
Well, it would not have been corroborated, but there was direct testimony from the victim and the boyfriend, yes?
Yes, but it would be directly contradicted by the state's own evidence had Exhibit 5 not been admitted, and then the defense potentially being prompted to admit further text messages without or with the golfer emoji.
And then why is 6 prejudicial?
Because that is the only, well, the court explicitly stated that was the evidence it used to fix the date. I believe it was pages 39 to 42 and 57. And I believe the state may have also claimed that was the intent of the use of that document.
Wasn't the intent of the use of the document simply to refresh the witness's recollection regarding the date? In fact, the exhibit wasn't actually admitted for proof of the date.
Right, but it also wasn't provided in discovery, and it was proffered into evidence, so we do have it here.
I'm looking at my notes here, and it says an Officer Peacock gave testimony to establish the date the messages were sent. So there was evidence independent of that exhibit to establish the date the messages were sent.
The only way he could have gotten that would have been from Ms. Hammond, so it would certainly call into question the credibility of that if Ms. Hammond's evidence couldn't be corroborated.
Was there any challenge when the officer testified as to the basis of his understanding of the date of the messaging?
I'll have to check and address that on rebuttal.
Okay, because obviously if there was no challenge, then
There
that's
was a
waived.
challenge to the exhibits.
Right,
and I was never,
but my question was on the officer's testimony.
I will check and address.
With regard to exhibits, you had mentioned early in your argument about there being a brief recess. Can you talk further on that, please?
In what regard?
You said that there was merely, something to the effect that there was merely a brief recess.
Correct. I don't have like an exact time frame, but it was a recess that allowed them to go back to trial that day.
Was the recess for the purposes for the defense to review the messages?
It was.
Okay, so the defense had an opportunity to review the messages, okay, and then what is your concern that flows from that?
That it was not adequate, that either the evidence should not have been allowed into evidence at all, or that a longer continuance should have been granted.
Was it raised at the trial court level that that recess was not adequate in order to review the messages and properly prepare for defense?
I believe the objection was maintained and not waived. I don't remember, I do not believe they said that specific argument against it, but they did continue to object to the evidence coming in.
Okay, so if I can understand, when you say that the objection was maintained, can you please explain how that's reflected in the record?
My recollection is that trial counsel said that they continue to object to the admission of State's Exhibit 5. I can get an exact site on rebuttal as well.
Okay,
But we also have the victim's testimony that she got these messages after the protection order was served.
Right.
So what's the prejudice with this exhibit if we've got both Officer Peacock and the victim testifying that the date that the messages were received was after the protective order was issued?
Well, I guess it just boils down to corroboration versus Mrs. Hammond and Mr. Watkins, both witnesses, having a motivation to lie here, which is what was raised in.
And the fact
Manifest
finder
Weight.
the fact finder can decide who they want to believe, whether all their testimony, some of their testimony, or none.
Sure, they're in the best position, but courts obviously still have the manifest weight standard to review these situations, and when the court relied on a date that should not have been used, admittedly, there was testimony, as the court pointed out, but The Mr. Watkins and Miss Hammond, they're in a relationship together. Both of them testified that they didn't really know Miss Lee or didn't text her, Mr. Watkins said. He said he had been in a relationship with her. Yet somehow they're able to testify to her messaging habits, which does not jive, does not make any sense in terms of knowing her and knowing if this was her sending these messages.
But there was something for the fact finder to rely on to conclude when the messages were sent. Even if it was not as direct as you would have liked, there was something that the fact finder could hang their hat on.
For identity, I would say yes. I still question the date, but yes, that's why it's not raised as a sufficiency claim. It's raised as manifest weight because it ultimately boils down to the credibility of these witnesses. If there are no further questions, I'll reserve the remainder of my time.
Thank you. Good morning.
Good morning, Your Honors. Opposing counsel, may I please the court? This is a really interesting case for a variety of reasons. First and foremost, because of how modern it is with trying to understand identity when we're thinking about technology and social media in general. So with a case like this where we are accusing the defendant of violating a protection order based on having a fake account with an alias, this is as modern as it can possibly get. So a lot is hinging on the trial court to evaluate credibility and go through each of these witnesses, the evidence that's presented, and to weigh what actually happened here, which is probably more difficult than in any other non-modern circumstance. As far as the defense's arguments here, for the first assignment of error, the record just does not reflect that the state willfully withheld anything. If we're looking at the exhibits that were used to really support the testimonies of witnesses.
Was there any sort of explanation provided by the state as to why these two pieces of evidence were not presented during discovery?
The state argued at that time, even at the trial court level, that there was a belief that these documents were actually provided to the defense. There is an additional detail saying, well, there were 25 documents of all screenshots of various kinds presented to the defense. It's not unlikely that this may have been overseen.
Like overlooked and not actually.
Overlooked by the defense, correct.
But does the golfer emoji or the date even really matter ultimately if you have the direct testimony of the victim and the other witness and the officer?
Not necessarily. They were potentially offered just for further support because of just how critical this identity issue is to this case altogether. But even if these exhibits did not exist, we had two witnesses who were separated for their testimonies, both saying the same things, that there was a golfer emoji signature used by the defendant. This is something that they know this person to do, to have fake accounts. So essentially, these exhibits were more supportive tools rather than everything hinging on them altogether.
But at the end of the day, what you had was testimonial evidence presented by the state, and the only direct evidence would have been Exhibit 5 and 6. Is that correct?
Your Honor, those were not the only exhibits that the state used. The state
Well,
also had.
direct evidence.
Correct. I would argue that the state did lean more heavily on the testimonial evidence. The exhibits that the state did use were to further support and, I would argue, add to the credibility of those witnesses to say that.
And I think that's where the defense is coming from, is when you have only testimonial evidence and then the direct evidence, depending on how it came in and whether it came in proper, at the end of the day, then that provides the trier of fact something other than the testimonial evidence to determine what actually happened.
Perhaps. I think just from an appellate level, just looking at the information that we have from the trial court.
And I want to get back to what happened with those exhibits with regard to, so there's and I'm going to use defense's terminology, a brief recess. All right? There was a brief recess where the defense was able to review these exhibits, right? What happens after the brief recess? Does the defense object and say that they require something else or that something else should take place?
Sure. For Exhibit 5, the first time there was that brief recess, defense counsel had the ability and the time to look over the document. When they came back on the record, there was no further commentary or objection or any other indicator the defense was not satisfied with that brief that brief recess. For Exhibit 6, there was a bit more pushback after reviewing Exhibit 6 by defense counsel. They did maintain their objection, but they didn't ask for anything else. They could have asked for either a continuance or maybe even a mistrial if they wanted to go that far, but none of that happened. So yes, the objection was lodged, but
Nothing happened
further.
at that juncture.
Correct.
But there is another juncture in which something does happen, right?
For Exhibit 6, the second
With
one?
regard to Exhibit 5.
Exhibit 5.
Exhibit 6, I believe,
Exhibit
yes.
6. As far as I
When
remember.
the state attempted to introduce the exhibits, what happened?
Well, there was back and forth. Clearly, the state recognized that defense counsel was a bit more passionate about the second exhibit being used and admitted than Exhibit 5 was. So the state chose not to admit Exhibit 6. It was proffered. That information was used strictly for date, but nothing more was done.
How was it used for date in terms of the testimony? Does this demonstrate the date and they showed the exhibit, or how did that happen?
As far as I remember, the witness had already said that they had received this message after the protection order was served. So that testimony already existed, that we have these messages that occurred. I believe the witness had even said it was August 15th, and this text message was just used to further corroborate that information. So that's my
And
understanding.
does it matter in terms of the rule that it was never really introduced, that is Exhibit 6?
What do you mean, Your Honor?
Under Rule 16, it basically says introduction of the evidence could be prohibited. Does it matter that it wasn't introduced?
I'm not sure, actually, Your Honor. I'm not sure.
Was the defense's theory below at all that it was essentially a Facebook clone account that was used to frame her with the golfer emoji?
I think part of the testimony that was pulled out from Cross, that it could have been other females that were potentially tangled with Mr. Watkins, other paramours that were potentially jealous or angry, or they may have portrayed themselves as the defendant. But if we did not have other bits of information that showed this type of behavior already exhibited by the defendant, perhaps that would have been a valid strategy. But we have other pieces of information that the defendant had another account blocked before for poor behavior on social media. We have other information testimonially that the victim and the ex-boyfriend have experience with the way that this defendant has spoken to them and texted them, for them to have that knowledge to then present. So even if there was that potential defense strategy, this could have been someone else, there's still plenty of information to circumstantially prove to the trial court, like, this may actually be the defendant. But of course, we don't have black and white proof of that. It's all circumstantial. Okay, no other questions with that particular assignment of error. Just moving on to the manifest weight of the evidence, it's not surprising that the trial court really just had to evaluate credibility here. There are a lot of people here for a former romantic relationship. Obviously, emotions are charged, and all we really have is to understand who's telling the truth here and what do they have to gain or lose. The other side is arguing that we have two testimonial witnesses who had something to gain from doing this. I don't see what exactly they had to gain from having their intimate information exposed on a trial court level in a very humiliating way. I think really, since this offense does lay on the question of identity, the trial court really had to just evaluate demeanor, tone, if this makes sense or not with what is being told here. And I think the trial court did that with the best of their ability. If there's no other questions from the court, the state will submit on its filings. I think there's a lot of information here that has been briefed. it's not a slam dunk case by any means, but if we're thinking about the quality of this case to begin with, it never was going to be in the first place. This is an issue of mistake, like of not knowing who the identity is of this person, but somebody did reach out to this victim after a protection order was validly served on the defendant. We have proof of that protection order being validly served that was admitted into evidence. We do have an understanding of timing with or without the exhibits that are at question here. So what we're looking at here is there was a protection order, contact was still continued, and it's the victim and the ex-boyfriend who corroborate that it was the defendant who did this and they shouldn't have. So, thank you.
Thank you.
I think everyone figured out the discrepancy on Exhibit 5's objection and Exhibit 6 for me, but just the state had the timing of it or the content correct. Objection before on Exhibit 5, no follow-up objection. Objection to Exhibit 6, then there was a follow-up objection on page 40. So there was a renewal there and never an explicit waiver on 5.
And it was Exhibit 6 ultimately submitted into evidence?
It was proffered into evidence. It wasn't admitted in the normal sense.
Okay. And Exhibit 5?
Exhibit 5 was admitted into evidence.
So should the defense counsel below done anything else as to 5? At that point where they were given a continuance, they examined the exhibit, they came back and they continued, were they under any obligation to object further or to make a record for the purpose of preserving the objection? At that point, they got at least part of what the rule contemplates, a continuance.
I think if we were talking about ineffective assistance, perhaps. But here, ultimately, the objection was lodged to the evidence. So the question becomes, is this a discovery violation, and was it done willfully? And I'd say that it was, and that there was no evidence. It was turned over. And then,
Well, I know, but there's no real record of that, right?
right, but
the defense
state
counsel
could have filed discovery, a proper discovery response, for instance, that would have been proof.
and defense could have demanded.
They did.
Well, I know, but after the objection, they could have further said, Your Honor, this was not included in the discovery packet, and I'd like to make a record indicating that, and because of that, my objection stands, and they did not do that.
They did not. The original, did he need to object again to preserve it? I still think the answer is no, in the sense that continuing on could have simply been a matter of trial strategy and not a matter of admitting you weren't prejudiced by it. Hence, admitting Defendant's Exhibit A later. That
So if it's
includes the
trial
law.
strategy, then how could it be error?
How could it be
Could it
error
be
to
error?
only
How could
give
it be
a short
reversible error
continuance?
if it's trial strategy?
Ultimately, because it, it would be essentially that a decision was forced upon counsel, and it ended up being an unfortunate decision, but the prejudice, I guess you could say, falls into being forced into that decision in the first place.
Well, in light of all the golf emoji testimony, how prejudicial is it?
Without corroboration, I would say very prejudicial. You've got people who, on the one hand, say they don't message or don't know Miss Gardner, and on the other hand, say, here's a bunch of messages from her, and she uses a golf emoji all the time, but they aren't there.
But
to-
her picture was used on the Facebook profile as well, right?
Sure.
She responded to, on the alleged fake profile, when someone referenced her name, she responded.
I mean, ultimately,
So the golf emoji wasn't the, I guess my point is, the golf emoji wasn't the only evidence that this Facebook account was being run by the defendant.
I'd say it was the only unique evidence, which was the whole point of bringing it up, in the sense that anyone could have gotten her picture on Facebook or made a new account. I believe Ms. Hammond testified to that. If it wasn't her, it was Mr. Watkins. It's not hard to pretend to be someone on Facebook, and I think that was brought up by the state, and, you know, this may end up being a problem we're forced to address in the future regarding, do we need evidence from Facebook or a telephone company to prove that the sender was actually using the device in question or actually was the sender? But ultimately, I would say that there is no weight to be given to having somebody's name or picture on a Facebook account, ultimately. And I think that is why they use the golf emoji, to try to prove identity.
But that objection wasn't really lodged below. It was more just, this is a discovery violation. That sounds more like an authentication issue.
I agree. I'm simply addressing the value of the picture and the name, and then also the state's argument during their portion. That's all. If there are no further questions, I'd ask the court to reverse and remand for a new trial. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission, issue a timely decision. Wish you both a wonderful afternoon and the rest of the week.
I would ask to reserve 3 minutes.
How many minutes?
3.
3 minutes, okay. Whenever you're ready.
May it please the court, counsel. The totality of the record in this case demonstrates the state's attempt to hodgepodge a case against Dee Dee. There are 3 complaining witnesses testifying, and not a single one testifies to the ID of Dee Dee. Rather, the state's case rests on an improperly admitted screenshot which lacks a proper foundation and is completely absent of a nexus to the alleged crime. The lack of foundation, authentication, and noncompliance with the best evidence rule for the improperly admitted screenshot is at issue in the first assignment of error. And like stated previously, in Dee Dee's case, there are 3 complaining witnesses that testify at trial. They are never shown the screenshot. They don't ID the screenshot. They never make an in-court ID of Dee Dee. And the court does admit, against defense's objection, this screenshot of Dee Dee in a vehicle. And the screenshot, it cannot be authenticated under either silent witness theory or pictorial theory. Under silent witness theory, there needs to be some kind of familiarity or the reliability of the surveillance system, some type of testimony as to where the cameras are, how the system operates. There was no one there that at trial that testified as to how the surveillance system worked.
But an officer testified about how they got the still picture.
Yes, they testified that they got it from and it was Exhibit 4 that was never admitted, that they watched Exhibit 4, surveillance, and made a screenshot from that surveillance video.
And they detailed the process by which they got Exhibit 4, watched Exhibit 4, and took the still photograph.
Partially, yes. They were not themselves, I believe it was Detective Newman, they themselves did not get the surveillance video. They testified that some unnamed officer got it, retrieved it. However, that officer was not present at court. They did not testify at trial.
It seems to me that your argument is that the authenticity of Exhibit 3 3 was the still, right?
Yes.
That the authenticity of Exhibit 3 is inextricably intertwined with the authenticity of Exhibit 4, and since Exhibit 4's authenticity was never established, ergo, Exhibit 4 was never even submitted, right?
Yes.
That admission of Exhibit 3 fails. That's the way I understand your argument.
Yes.
Okay.
I believe under best evidence rule, it would be improper if you cannot establish the foundation for the underlying video. It's improper to admit the still.
But didn't the police say they got the video from the drive-through?
So the Detective Newman said that another officer went and retrieved the surveillance. I don't believe that there was much specificity as to where it came from or who they talked to, anything to really, there was no testimony about the reliability of the surveillance system. These are issues that are required if you are trying to authenticate under silent witness theory.
But under silent witness, the still photo showed the defendant.
Yes,
And he, in fact, confirmed that was him in the still photo.
yes.
And it also showed his car, is that right?
It showed part of the car, yes.
And the victim identified that was the same car that almost hit her.
Not from the still. So what Ms. Williams had testified to was a separate surveillance video than what Exhibit 4 or the still 3 Exhibit 3 came from. She testified about a blue car that was just in a separate surveillance video. And
Did anyone raise any evidence to question the authenticity of Exhibit 4, the entire video? Was there any information that this had been concocted somehow, that it had been created?
There were objections as to the playing and admission. Well, there was no admission of Exhibit 4. There were issues as to, there was no one there to testify as to the authentication or foundation for that. I believe that you can kind of compare it to Exhibit, I believe it was Exhibit 1, that surveillance video. That came in through pictorial theory because the witness was able to ID her own car in that video. However, it's completely different where in Exhibit 3, the still, there is Dee Dee saying that's me in that car, but there is no time stamp on that photo. There is, I would say it is absent of context of where the photo is. We don't really, it isn't in the record.
Well, my question was specific to the authenticity of either the video or the photo. Did anyone submit any evidence that either the video or the photo was faked?
I think there were just questions as to how is this coming in, because there was no testimony as to that this is accurate, that this portrays and is a true and accurate copy of anything or video.
Well,
of
Dee Dee
anything.
testified that it's him in the car.
Yes, he was shown the still and asked, "Is this you?" And he says yes, but he asked to see surveillance, and the record doesn't say that there was ever any. He was ever shown that, and so I do believe that it would be akin to seeing a photo of yourself and saying, yes, that's me, but not really having the context of where this is coming from, what are the surrounding circumstances. I think time would be an issue as well, what time it happened at.
How soon after the event was Dee Dee shown the picture?
I don't believe that was in the trial record. I don't think Detective Newman could remember.
Was it that day, though? The day of the arrest?
The record doesn't say. I don't believe so, based on the testimony that Detective Newman gave. She was assigned this case a year after the incident, and so I don't believe so. The second assignment of error is that Dee Dee's adjudications for ag menacing were against the sufficiency and manifest weight of the evidence where the state failed to prove identity beyond a reasonable doubt. And again, 3 complaining witnesses testified about the alleged threat. None of the 3 witnesses were shown the screenshot during the trial, and none identified Dee Dee during the trial. This is similar to State v. Nicholson, which was in the defense brief, or the appellant's brief, where officer could ID who defendant was. There was, he saw him entering into his car and driving. There was a pursuit, and then he did lose sight of the vehicle. Later on, he comes up to the vehicle, and they say that basically this was too circumstantial, and that he doesn't know if there was someone else that came into the car. He doesn't know if there was anything else that occurred that would have changed who was in the car at a certain point in time when he lost sight of the vehicle. And I do think that that is very similar to what happened here, is that there is a still photo, again, absent of context surrounding where the still photo came from. And that is just not enough to connect a still photo to an alleged crime. I believe that there is a nexus here that we are missing. And another case is In Re DB, and in Re DB, the court found that statements were not enough in that case, where DB admitted to riding a Metro bus and getting off a bus near a BP gas station, walked away from BP in direction of Washland, where an alleged shooting had occurred. And the court determined that even if DB were in the vicinity of the crime, this is not enough to prove guilt. And without anything to connect DB to the shooting in that case, it was not sufficient evidence to identify him as the shooter.
Well, in this case, we've got a victim testifying that a blue car pulled out of the drive-through and almost hit her, and that was the car where the individuals pointed a weapon. Is that right?
Sorry, can you repeat the question?
Sure. The victim identified a blue car in the surveillance video, in a surveillance video. I think it was Exhibit 1.
Yes.
And she said that's the car that pulled out of the drive-through, and that's the car where the individuals were riding that pointed a gun at her.
Yes.
And the still photo was from a surveillance from the same drive-through.
That is, I guess it is purported, but I don't believe that that was established through the record and through the testimony that was given at trial.
Well, the officer said that she created the still photo from the video from the drive-through.
That is what she testified to, yes.
And Dee Dee stated that that's him in the car in the drive-through.
Yes.
And that same car is what's shown in Exhibit 1, almost hitting the victim.
And I don't believe that that was established through the trial record either. And I think that at most, even if we are to say that the still shot of Dee Dee in a car, I don't believe that there was enough testimony to say that that is the same car that Ms. Williams does identify. And again, with the time difference, or the absence of a record of time from when that photo was taken, where it was taken, I believe that there is a possibility that he got out of the car, that someone else, I believe that he was with three other individuals, and there is no testimony to say that, no one switched seats. We don't know what happened in between still photo and what Ms. Williams was able to testify to. And again, I would just reiterate that the statement of Dee Dee identifying himself in a car puts him in a blue car. But we don't know the time, we don't know where, we don't know the context surrounding this screenshot, and I believe that in this age of AI, where we are in this, as a society today, it is important for courts to ensure validity in admission of evidence, and I believe that is why there is authentication and foundation rules for evidence to be admitted into trial, and we are asking the court to reverse the adjudications. I will reserve the rest of my time. Thank you.
Thank you.
Morning, Your Honors.
Good morning.
Morning, Counsel. I wanted to address, before I get to the Exhibit 3, 2 points. One relates to the other. It has to do with what is the evidence in this record. I was a little taken aback. The reply brief said I was referring to facts that were not in evidence and that this court may not look at. And it has to do with the 911 call. The prosecutor said, it's on transcript page 26, she asked that the 911 call be admitted. It's State's Exhibit number 2. The court said, yes, it's so admitted. Then on page 28, the prosecutor again referred. She showed 4 minutes and 16 seconds, played 4 minutes and 16 seconds out of a 7-minute 911 call that Wendy Williams made. The prosecutor stopped it at 4:16 and said, Your Honor, I think I'll stop it here. I'm not sure that anything, we need to play the rest. And then she said, I'm not offering these statements to prove the truth of the matter asserted, but this is just a complete copy of the 911 call, as Ms. Williams made it on the date, with all of the information she provided to the officers. She said, I'm going to stop it at 4:16. I think the rest of this is about other matters, but I would ask that this, up to 4:16, be included in the admission of State's Exhibit number 2 as having been published. So to me, the whole 7 minutes, the entire State's Exhibit number 2 was a part of the record. What this led me to think about, and you three were not on these cases, but there's an issue in the Ohio Supreme Court right now about what is in the record. There's a case, Michael Jones. The state admitted 2 body-worn cameras, films. And then when it was put into the evidence, the state used a DVD that the 2 were on. But it also happened that there were a lot of other body-worn camera videos on the DVD, but only the 2 were admitted by the court, and that's what the state's intention was, only show those 2. When the opinion came out, this court considered all of the DVD, the entire DVD, all of the body-worn camera videos, even those that were not admitted. This went up to the Supreme Court. There were 2 opinions, Michael Jones 1, Michael Jones 2, then it came back again. The state appealed it again to the Ohio Supreme Court. And they have the proposition of law. It's up there now. It has not been decided. On appeal, a reviewing court is limited to the evidence admitted into the record by the trial court. All right, and the reply brief says that this court is not allowed to listen to or consider 4 minutes and 16 seconds to 7 minutes, which I don't think that's correct, because the entire 911 call was admitted in the record.
So it seems like it's a little different to Jones because it's about what was played as opposed to what was admitted. Am I understanding that correctly?
Well, when the state appealed.
I'm talking about in this case, the 911 call,
Yes,
right? The entirety was not played,
correct.
but the entirety was admitted.
Yes.
Okay.
And there were a few facts that Ms. Williams got more specific about in the last couple minutes. And the reply brief of the defense said, this may not be considered by this court, what she said. I think ultimately it would not change the outcome of the case. She talked about a 9mm. She said, I think it's a Glock. That was in the last couple minutes. She also said one of the people in the car had a pudgy nose and that someone had on a gray shirt. She said in that part of the 911 call, they were
I want to make sure I understand because I want to get to State Exhibit 3 during your argument, okay?
All right.
So a portion of the 911 tape was played, right? The entire 911 tape was provided in discovery to defense?
Yes.
Okay, so the defense had the opportunity to review the entirety of it, right?
Yes.
And then when it was admitted, the entirety of the tape was admitted?
Yes.
And was there any objection lodged at that point as to what was actually in evidence? In other words, limiting the tape to a portion, or specifically to the portion that was there played in court?
No, I don't believe it was.
Okay, then can we move on to Exhibit 3?
Yes.
Okay, so with regard to Exhibit 3, as I understand the issue, and I'm going to re-articulate it as I had earlier, that Exhibit 3 is a still of Exhibit 4. Exhibit 4 is a video that was not admitted into evidence, so there was no authentication of Exhibit 4. Am I good so far?
Yes.
Okay. And so I understand the argument is that the authenticity of Exhibit 3, now these are not her words, these are my words, are inextricably intertwined with the authenticity of Exhibit 4.
Yes.
Okay? Can you please explain to me how that is faulty?
I believe that Exhibit 3 was sufficiently authenticated. The office, Detective Newman, went through the steps of exactly how she obtained this video. It involved the first officer who gets surveillance videos. He used his cell phone and taped it, because so many surveillance videos at businesses often get taped over. They're inexplicably not able to be watched. That some of them require very technical computer programs to even try to transfer it or get to it. All right, so.
So
she's-
when did Officer 1 make the body, I assume it was a body-worn camera recording of the surveillance? When did that happen?
That, my understanding is it occurred shortly after the crime.
Same day, as part of the response.
I'm not absolutely positive the same day. I'd have to go back in the record. Then he brought it to Detective Newman. So she played it and took a still shot. The still shot was used to say, she took it to the officer whose beat was that area on Harrison Avenue, and just said, "Do you recognize this person?" And he said, "Yes," and he identified Dee Dee. The police go out and bring Dee Dee in for an interview. The officer specifically referred to the crime that occurred on June 26th, and saying to him, "This is what we're looking at," and where it was, what time. He said, he mentioned it was him in the vehicle. He identified himself in the vehicle. Yes, on that date, yes. Did he tell you anything else about the incident? She says he didn't mention a lot about the incident. So there's no facts of what he actually did say, but there was no denial.
So except for Dee Dee's fateful self-identification, no one else identifies at trial that that was Dee Dee in the picture?
Correct. Ms. Williams, yes, Ms. Williams, who was in the car, and all of her sons and her nephew did not identify Dee Dee.
Were they shown the picture at trial?
No.
What establishes that this still photo was from video that was taken at the time of the incident?
The video itself was shown to the trial court as an explanation of how Detective Newman came up with the still shot. And that this was the same day, almost the same time. It was
And I
shot.
guess that's the question I have. What establishes that the video was the same date and the same time?
Detective Newman's testimony.
But Detective Newman relied on another officer's statement to her that that's how he or she got the video.
Yes, yes, exactly. An officer whose, one of his duties was, or his areas, was to get surveillance videos for officers.
But no one with personal knowledge testified that the video that the still was taken from was captured on the same date at the same time as the incident.
The officer who captured it did not testify.
And that's the only source for that information.
Detective Newman's testimony about how she got it,
Okay.
which makes it a matter of credibility for the trial court. And I think her testimony was sufficient. Her testimony, combined with his identification of himself, was sufficient authentication. And when she showed it to him, and she said, this is from this day, in this location, here is the crime we're talking about. And he said, this is me in the car. And he didn't want to add any details about what the officer said had occurred that day.
All right, so what Dee Dee testified, at some point during the day, I was at this drive-through.
He did not testify in court.
Well, what he admitted to,
Yes.
when he identified himself in the picture, was simply, that's me in the car at this drive-through on this day that you're saying this video was captured.
Yes.
But there's no one with personal knowledge established that it was taken at the same time of the incident.
The officer who told Detective Newman that, he had gotten it, and this is what it was from, and this is the date,
He didn't testify.
he did not testify.
And Officer Newman didn't have any personal knowledge of when the video was captured.
She did not go to the drive-through at any time, correct?
So how do we establish that this video that led to the still was at or near the time of the incident without that testimony?
Well, you've got the testimony of Detective Newman saying, this is what the officer went and got it, and this is what he brought it to me, and then it was from that date of that incident. Now, the actual film, State's Exhibit 4, would have had timestamps on it, but that was not admitted by the state. The state did not try to admit that.
Well, so why was that? Why not just admit that and say, I'm giving you Exhibit 4, it is the surveillance, it's exceedingly long, you can watch it at your leisure, and here's the still picture captured at timestamp, 1513 or whatever. Why not do that?
I am guessing, I'm guessing that the person from the drive-through that was going to authenticate the video didn't show up. And we know from looking at it that the officer that filmed it on his body cam, gave it to Detective Newman, did not testify. So I'm assuming he was not in the courtroom. I mean, this is what I'm gathering.
And Attorney Lapp, as you're talking about, as you're characterizing Officer Newman's testimony, did Officer Newman's testimony include that he personally observed the other officer going and retrieving that video?
No.
So he was just saying this is what he believed happened?
Yes.
That's the essence of the testimony, that this is what he believed happened before it came to him.
That this is what, it just happens, it's a woman, like Detective Newman. She said that the officer.
That she believed happened.
Yes, that he recorded it, brought it to her, said, this is what, here, I videoed this, used my body-worn camera to video the surveillance video that I got from the drive-through. But he didn't say that at trial, she did. She's explaining the circumstances of how she came about this. And so that she created one still shot that was used to say, you know who this is? To the officer from the beat.
Would you like to wrap up? You have 30 seconds.
Even if Exhibit 3 was not being admitted, Detective Newman could testify that in my investigation of this crime, here's what I did. And I found, showed a photograph of who we believe the suspect was to Officer Mullis, who did testify, the beat officer. And he said, yes, this is D.D. Officer Mullis testified. And he said, yes, I know him. That's my beat. I've met him. And she then said that she brought D.D. in for questioning. And then he said, yes, that's me. And she specified it was this date, this location, here's the crime, we're talking about. And he said, yes, this is me in the car.
Okay, thank you for your argument
Yeah,
this
I'm
morning.
sorry, can I ask
Of
a quick
course.
question? You mentioned that there were timestamps on the video. That was not admitted, is that?
Not admitted. And there is no time stamp on the still shot.
Okay, that was my question, thank you.
But you do have it in evidence, but when I looked at it, I did not see any. Where there would have been a timestamp, it was something about, it was not the timestamp from that day. Something was covering up the bottom of the picture.
Okay, thank you.
All right.
And just briefly, as to the 911 call, I did just want to cite to Crump and Olin, which this court decided. And in those cases, the judge decided immediately after the trial and they did not review the portion. They made the decision of the trial immediately after the trial. They didn't review the portion of the video that was presented. And so the state.
Was I on that case? It sounds familiar.
And the state in their brief likened the race and head coverings to export circumstantial evidence, but even at trial, the state did not offer, they said that they were not offering it for the truth of the matter asserted, and defense only expected those first 4 minutes to be introduced. I believe that even the state, when they were introducing it, they said, I think the rest of this is about other matters, but the portions that were played, minute marker 416, I would ask that be included in the admission of State's Exhibit 2 as having been published. And I did also want to clarify.
So those are two very different scenarios. Which is it that applies to this case?
I believe that they were only admitting up until 416. I believe that that's what they played.
Is the record clear as to what was actually admitted or what portion of the video of the 911 call was admitted?
I believe it was up to 416, but that is, I will also just note that the court only heard up until 416. They made the decision immediately after trial. There was no
Okay, so then the first scenario is what applies, which is what the trier of fact, in fact, considered in rendering its decision.
Yes.
Okay.
And I also did want to clarify that there was no testimony of when D.D. did identify himself in the still shot, there was no testimony from Detective Newman or D.D. that the photo was taken at the drive-through. That was never presented in the trial court. And I would just submit that there is not enough evidence here to ID D.D. Without the still shot, there is no connection of D.D. in any way to the alleged offense, but even with the still shot, there is no nexus to the alleged criminal conduct. And so, again, we are asking the court to reverse the adjudication in this case.
Thank you. Thank you both for your arguments this morning. We'll take the matter into submission and issue a timely decision. Wish you both a wonderful afternoon and a great week. Good morning. How are you doing?
Good, how are you?
Good, good.
May it please the court, my name is Katie Barbier. I'd like to reserve 3 minutes for rebuttal, please. I'm here on behalf of the appellants. It's the defendants in the action, Springfield Township, the estate of Timothy Unwin, who was a police officer for Springfield Township who perished in this accident, and then Rick Bly, who was the safety service director for Springfield Township, who was the police chief at the time of this incident and is no longer the police chief. So here, we're here on a case, this is a political subdivision immunity case under Chapter 2744. It is the position of the Springfield Township and the arguments advanced in our briefing that the officer was on an emergency call at the time of this incident, that the officer's conduct was not wanton, willful, reckless, or malicious or in bad faith as required to be for an exception to immunity under the statute, and therefore all the defendants are entitled to immunity with respect to these claims. There are 3 claims for relief alleged in the complaint. There's a willful, wanton, reckless, malicious conduct, negligence claim that's kind of tailored all together as, I guess, claim for relief number 1. There's a wrongful death claim, and then there's a survivorship claim. And then there's also a claim for punitive damages, which we've opposed, and the trial court's decision was not kind of clear as to what she was denying or what was being denied with respect to immunity or not. So we've appealed the entirety of the denial because we believe immunity is applicable to all of those claims. So the kind of before I even jump into the analysis with respect to that, the first issue, kind of a unique issue in one of these cases, is that there is an estate involved, right? The estate of Timothy Unwin, as the officer did die with respect to this accident. And under the statute is 211706, there is a requirement of a presentment of the claim to the estate. After a decedent passes, a claim for relief, a tortious claim, which would be a wrongful
And there's a
death claim.
timing to that presentment.
Correct. There's a 6-month timing. There must be the claim must be presented within a 6-month time period. It's been our argument throughout here that was not done here.
So the letter that was sent was not enough?
No.
Why not?
The letter was sent to either Springfield Township. Chris Gilbert received a letter. He's the township administrator. The statute requires the letter go to the administrator or executor of the estate, an attorney who has been entered appearance as of record in the probate court, and that is representing the estate, or to another individual that was actually received by the executor or the administrator of the estate. In addition to those directing requirements with respect to who it goes to, there has to be an amount that includes the amount of the claim, that enables the representative to provide for the payment as part of that, and that it serves to bar all other claims.
Who did the letter go to exactly?
There was a couple letters sent.
The September 14th letter?
That went to me.
And at that point, you were representing Unwin?
I was representing the estate of Unwin through Springfield Township's insurance risk pool. Essentially, I was insurance counsel. I hired by Springfield Township. I was not the attorney of record with the probate court. That was, I think it was Edward Bender, who represented the estate and is, I think, still part of that representation. So there is case law out there, and I cited it in my briefs, that just making claims to insurance counsel is not enough to be considered a presentment to the estate under the statute.
Had the estate at that point been actually established? Was there an attorney representing the estate?
Yes, I believe there was, and I believe that is also, I think I included that as exhibits to my reply memorandum with respect to the summary judgment briefing, because I included the probate records, the docket statement. So, and then so what I'm just saying is, with respect to that, I don't think that there was accurate presentment, and I think that is a forever bar to this claim. Now, there has been some argument in the summary judgment briefing that there should be an equitable establishment, that, they did reach out to me, they reached out to Springfield Township. I don't think the Supreme Court acknowledges that. There's the case Wilson v. Lawrence. It's 150 Ohio State 3rd, 368. That just says these are not suggestions. There's no equitable principles. This is a strict application because it is for the way that estates have to close themselves. This is the result of the fact that we don't want surprises down the road. And so I'm just saying that presenting to
Was this a surprise then?
To this estate?
Yeah.
I mean, probably not at this point. I mean, it might have been a surprise, at the time it came in, but it wasn't a surprise within the 6-month period. But I still think that there's the statute, the Ohio State and the statute requires strict adherence, and I don't think that was met here, the statutory requirements.
So all the cases that you cited state that strict adherence is required?
Yeah, and that's a 2017 case, Wilson v. Lawrence. And then there's also Shepherd of the Valley Lutheran Retirement versus Sesta. That's an 11th district case from 2019, and that reiterates what was presented in Wilson v. Lawrence, that there are no equitable principles at issue here.
So what if the estate was out, the township would still be in, correct?
Correct.
And that just the estate, and I agree, that's not a major issue, that wouldn't be dispositive of the claims against the township, because the township can still be responsible, but that's a different analysis under the immunity statute, right? Because
And the township is still indemnifying theoretically Unwin's estate under the insurance policy.
yes,
So,
yes, but it is an argument I'm making with respect to
and
these claims.
wantonness is more than recklessness, yes?
Yes, so that's the important aspect of this, is for the fact that if Springfield Township is going to be held liable, right, under the emergency call and the immunity analysis, it's just wanton and willful, which is a higher standard than recklessness. Recklessness goes to the individuals only, which would be Rick Bly and the estate of Timothy Unwin. So if we're looking at the liability of Springfield Township without the individual liability, of estate of Timothy Unwin, we're looking at wanton and willful, assuming that the court finds that this on an emergency call, which we submit that it is, and I can talk about that a bit, because there's been some.
So assuming it's an emergency call, why isn't whether or not this is wanton a question of fact for a jury as opposed to something that should be disposed of at summary judgment?
Well, I think there's, the way that Agarbright v. Neer, directs the court, that Supreme Court case, if it is clear, there is a question of law with respect to wanton and willfulness. I mean, they say that closer questions are questions of fact, but the courts have said that that is a high standard, especially in cases of police, pursuits or arrests or whatever it might be, is a high burden for a plaintiff to prove that the officer was, acting outside the course and scope of his duty and doing conduct that was more than negligence, because obviously we want our police officers to be able to respond
I mean, this
to
is
calls.
clearly not outside the scope and duty. It's a question just simply of whether or not it was wanton within the scope of his duty.
Correct.
Or at least that's how I think of it. They could
Yeah.
the township could still be liable then.
The township could be liable for wanton or willful misconduct with
So
respect to the
why isn't
emergency
this like a close call then? It seems like he was going at an excessive rate of speed. It was an emergency call. It seems like reasonable minds could disagree about whether or not that reaches that level of conduct as a question of fact.
And that's what the trial court determined. I guess our position is it's not that close with respect to the fact that this was an extreme call for service. An officer from the Springfield Township Police Department was being assaulted in the middle of the roadway by an individual who was wanted for arrest, who was, I think he was hit with a closed fist several times. It was a like top tier emergency for Springfield Township. There was a dispatch.
Did Officer Unwin, is it in the record that he knew that this emergency call had been resolved by the time he was, because that's apparently some issue, and he was driving extremely fast, and I just questioned, did he know at that time that the emergency call had been resolved?
So the call was cleared.
Okay.
But what Officer Unwin knew obviously is unknown to us, since he didn't survive the.
Well, was there any evidence that this was dispatched to him that the call was cleared?
There was evidence that it was dispatched to him through the CAD report. There is not evidence that he was generally aware that it was cleared, other than the call was cleared.
Okay, so he was told it was cleared through the CAD, we know this through the CAD report.
Right.
Okay,
But
and
what he saw in his cruiser and, what he took note of, I don't know.
It seems like he was very set on getting there as quickly as possible, and reading the CAD might have been, there's just no evidence that he actually saw the CAD.
We don't know that, yeah.
But there was evidence as to what the policy is.
Right.
And then there is case laws to call to duty.
Call to
And so I
duty.
think your argument is that because of the policy of the department, that it fits into call to duty.
Correct. Like the policy of Springfield Township and the training of the officers is that they are required to continue responding even after a call is cleared when it involves one of their own officers.
Okay.
And
You only have a few minutes. I do have a question
Yeah.
that I want answered, okay? With regard to willful and wanton, is that viewed from the perspective as to Officer Unwin hitting the vehicle of Dunson? Whether it's willful and wanton in the hitting, or is the willful and wanton viewed from the perspective of the speeding that led to the hitting? Do you understand the question?
I do understand the
Okay.
question, and what I would address is I think you have to look at the harm, right? He has to have knowingly, the willful and wanton definition, right, is that he has to,
intentional deviation from a deliberate purpose not to discharge some duty necessary to safety. So I think you have to look at it in the context of Mr. Dunson and whether Officer Unwin was, knowingly discharging a duty to safety in order and such that was going to result in harm to Mr. Dunson.
So it was a posted construction zone, yes?
Was a construction zone, correct?
And does the policy, some police department's policy basically dictates that you slow down at certain junctures, including intersections, lights, school zones, posted construction zones. Does Springfield's policy speak to that at all?
There is language in the policy with respect to that, and the police chief and the safety service director addressed that in the way that this was a Code 3 response due to the severe nature of the call, which
So
allowed-
Code 3 means
You can
just
go-
get there as fast as possible.
I mean, within, safely, but
Right,
it was.
so isn't that within safe, with getting there within safety, is that a question of fact?
I mean, that's where we're submitting it's not, that it was, after midnight, it was, a relatively, not well-traveled area with respect to that time of night. It was a straight roadway, so that's the facts that we're looking at. That's the facts that we were presented with here. I see I have only 30 seconds left. Are there other questions? I would touch on the fact that, there's also a proximate cause issue for Rick Bly. There's, in addition to the immunity arguments, which we're kind of arguing all the way through, the plaintiff is suggesting that Rick Bly's just hiring and retention of Officer Unwin approximately caused the death of Mr. Dunson. And I would just submit, one, that's not a reasonably foreseeable,
Well, is that really even before us, the issue of proximate cause? It wasn't determined on proximate cause below. It
wasn't
it was more just the immunity. So
Correct.
what is how could a failure or a negligent hiring ever be wanton?
I don't see that
From
it
your
can.
perspective.
I don't see that it can. It can't be wanton. And there would be immunity and there would be discretionary, decision-making with respect to personnel that would also reinstate immunity under the statute. So there are many levels to the immunity there. And I see I'm out of time, but I have 3 minutes for rebuttal, or else I can answer any questions. Okay, thank you
Thank
very
you.
much.
Good morning.
Good morning. May it please the court, Ms. Barbieri. I think I want to jump into, before I go to my presentation, I'll jump to the presentment issue since it was touched on initially by counsel. At a minimum, with respect to the presentment issue, there's certainly, and the trial court, I think, agreed with the conclusion, there's certainly an issue of fact with respect to the written demand, which has been discussed, that was sent early on in the litigation to, I believe, Ms. Barbieri as counsel on behalf of the township and Unwin, in addition to multiple communications about mediation, about setting a mediation. A demand was ultimately set, and I believe the demand was for policy limits. And in these type of cases, generally, plaintiffs don't know, unless we've dealt with the political subdivision before, what those limits are. So that is not out of practice as to the demand is considered. So
Was there strict adherence to the requirements?
I believe it was strict adherence with respect to the statute 211706. The statute specifically says the executor, administrator, or counsel. At that particular time, we had been negotiating with Ms. Barbieri exclusively, and it was represented that she was representing Mr.
The statute
Unwin.
uses the term counsel, does not use the term counsel of the estate.
It does not use that term. So it
And the
does-
case law has not interpreted it to be exclusively such?
It is not, and we've cited case law, which I know the appellants in this case have attempted to distinguish on the actual facts before that case, but one of the cases that we cited was a similar case where counsel, not necessarily probate counsel, was served with notice of a claim with respect to the probate estate. And I will talk about, this issue of presentment. We are really talking about who's paying the bill kind of at the end of the day. The township is going to indemnify Mr. Unwin with respect to any damages that are going to happen with respect to this. So it really is an issue that comes up after some sort of verdict or some sort of judgment with respect to the underlying claim. So, certainly, it's a conversation to be had, but we do believe it's at least an issue of fact, which I think the trial court came to the conclusion on the issue of presentment, and certainly something to be
Well,
considered.
so if it's an issue of fact, it just seems, it can't be an issue of fact. Like, the jury's never going to decide, like, when this presentment happened. This is not like a fact-finding issue. It is, was this presented to the correct person? And it might make a difference because theoretically, you could be proving recklessness against the individual defendant and a much higher standard against the township, so it provides the township with at least a defense to the recklessness.
Yeah, and that's why we've made the alternative. We've made the argument that it was presented appropriately under the statute to counsel for the estate, even though it wasn't presented to the exact probate, the attorney of record on the probate court. And I will note, not for the record, it's not on the record because it happened after the motion for summary judgment, but we have moved to keep that estate open in Butler County, and we cited the trial court's decision on the summary judgment motion. And the probate court decided to keep it open based on that particular submission. So obviously that was not before the trial court, probably not before you all as well, but for the purposes of what's going on here, the probate court certainly could have enforced the rules in a different way and chose not to with respect to whether or not that estate was put on notice appropriately.
So you agree that recklessness is less than wantonness, yes?
I agree.
And in that circumstance, the level of proof against Unwin individually might be something less than would make the township culpable under the wanton level of culpability.
Sure. We believe the conduct in this case reaches every level necessary under the immunity statute, whether it's wantonness or recklessness.
And so what is your evidence and how did it go on as to recklessness and wantonness?
Sure. Well, the first piece of evidence, and although speed in and of itself isn't something that's necessarily determinative of that particular fact, but it's a totality of the circumstances. So you have Unwin is traveling 78 to 84 miles per hour in a construction zone, posted 24 miles per hour construction zone. He makes an aggressive, reckless lane change passing maneuver. And what needs to be clear is there's another officer who's also responding to the same call, Officer Weil. He's with a different police division. I think it's North Hill. I can't recall which police division it is, but there's another officer responding to the call as well. He slows down because he reads his MDT, the CAT system, and says, okay, the suspects are in custody. There's no longer an emergent issue. He slows down, and ultimately he's interviewed by the Hamilton County Sheriff's Office, and as part of the investigation, he sees Mr. Unwin in his rearview mirror coming up incredibly fast, gets over to the right so he can, because he sees Unwin trying to make a passing maneuver on the left.
What street is this?
This was on 70, I think it's 70, Hamilton.
So this is on Hamilton and North College Hill.
Yeah.
And North College Hill and Springfield Township are responding because it's an officer needs assistance.
That's right. So, what happens is the MDT gets updated, and they basically say the suspects are in custody while the other police officer slows down because he sees that update, but then he also sees Mr. Unwin coming from behind him. Mr. Unwin makes the maneuver to the left, doesn't brake, loses control, hits a median, goes airborne. He's not wearing a seatbelt on top of that. There are some allegations that he failed to use his siren. I know there's some debate about the particular fact, but there's an independent witness who claims she never heard a siren at that particular time. He has a prior driving history, which we referenced, with respect to the claims against Bly and the township on the negligent hiring and retention.
Can we talk about that? The claims against the police chief, what is your theory against, why is he individually liable?
Sure. With respect to Bry, we're not saying that, here's my notes here, sorry. We're not saying he's ultimately responsible for the crash. What we're,
You're arguing, it seems like,
sure,
and I didn't get this from your complaint because I didn't really see it in the complaint, but what you seem to be arguing is negligent hiring and supervision.
Sure. We're not saying he should have foreseen this exact crash, right? What we're saying is the liabilities tied to his hiring, retention, and supervision, despite knowledge of his dangerous conduct, yes.
So how so? How could that be reckless? I mean, unless this officer was involved in like a police pursuit accident like this before he was hired, which certainly is not in the record, then how could this be a reckless hire?
Well, it sort of goes to the retention piece with respect to Mr. Unwin. And our argument is that it's a natural and probable consequence of retaining an officer like Unwin that this would happen based on his prior conduct and based on...
What's the prior conduct that's so bad?
He was involved in another accident with another plaintiff or ward, another case. It was another speeding case as well, which he caused injury to that particular plaintiff as well.
Is this one case or two cases?
There's one additional case.
And what was the timing of that?
I don't have that information directly in front of me. It was within the same time frame of this particular accident as well, because it's another lawsuit that's pending as well.
Is there any case law to support that that is sufficient? to meet
It's
the-
it's an issue of fact. So as far as whether or not there's any case law, I think it's for the jury to decide ultimately.
Well, I mean, the way
can't-
these immunity cases play out is, you know, if there's, if the facts cannot really sustain, whether, you know, it's reckless, whether it's wanton, it just cannot in any scenario sustain it, then it's not going to survive summary judgment. If there's a possibility that it could meet that, then it will survive summary judgment, right?
Yeah, and that would
So
be-
that's where case law kind of comes in to help direct that.
And I understand that. In this particular case, we would argue that it's a position of the appellees in this case that a jury could conclude that the township and Bly were responsible under those circumstances. And we think the trial court agreed with that particular conclusion, that ultimately, what you have to be able to find is that there's no version or there's no way that a jury could have found in favor of the plaintiffs or the appellees in this case on any of the facts that we're talking about. And ultimately what
It's basically, as a matter of law, given these facts, there's not going to be any liability.
Because what the appellants want you to do is they want you to basically take their version of the events as the only plausible version of the events. And the issue is whether on the Civil Rule 56 record, in our favor, that a reasonable mind can differ on a number of issues. We haven't talked about the emergency status, but even if you concede the emergency status issue, I would argue that ultimately you should still affirm on the issue of whether or not the conduct was wanton recklessness and whether or not that conduct was ultimately satisfies the immunity statute.
And
So-
can you address that, whether it's wanton and recklessness, as to how you would argue that?
Yeah, so, and I think apologize for, so again, this isn't just a speeding case. This is a speeding plus speeding in a construction zone. This is a speeding plus an aggressive lane maneuver. This is a speeding plus violating
So
multiple
what makes the
policies.
construction zone special? And really, the heart of my question is, what's in the record that establishes that the construction zone is special?
Well, one of the facts is that the other officer who was engaged in the same pursuit slowed down. And ultimately, the other fact is that he lost control and killed another individual who was traveling on the other side of the road as well. There were other people present as well. And just the nature of a construction zone. And I believe we have expert testimony as well. We have an expert report that's in the record as well.
That's what I'm asking. What I'm asking is, what's in the record to establish that that there's something special? Because, 25 miles an hour
Sure.
there must be a reason why it's 25 miles an hour and isn't 50 miles an hour, right?
Well, yeah, so as far as any testimony from like an engineer or anything as to why this particular area is designated as 25 miles per hour zone, I couldn't necessarily speak to that. But what I will say is that the Springfield Township policies certainly contemplate these type of facts where they say that no task, and this is within the emergency response context, no task justifies the reckless disregard for the safety of innocent people who are, even though at that early hour were traveling on that particular road. And there's also a due regard element with respect to the policy as well that says you still have to operate your vehicle within the context of a due regard.
Does that apply in the Code 3 scenario? It seems like it was like, Code 3, have at it.
Yeah, the language that no task justifies a reckless disregard for safety of the innocent is not qualified whether or not it's a Code 3 or not. That is.
Do the different codes justify different levels of conduct
I
in
don't know,
regards to response?
There's no testimony to establish that. We do have an expert who says that not only did this violate those policies, it violated the practice and custom of what you would expect of law enforcement officers responding under those particular circumstances as well.
Was your expert deposed?
No, ultimately, I think the motion was, I can't recall when the motion for summary judgment was filed, but.
Was your expert's affidavit submitted in opposition?
Yes.
When you're saying under the circumstances, was it also including the fact that this was downgraded and it was communicated that it was resolved? Because there's a difference there. You were just talking about an officer who slowed down once he found this out.
Yeah, so there's multiple tiers, right? So the first question is whether or not there's an emergency, right? And we would argue that the emergency had ended. We don't argue that the initiation of the call was emergent and serious, but when you get the MDT update that says that these two suspects are no longer.
So you're not arguing that there's no call to duty, you're arguing what are the circumstances that are to be considered in determining whether it was willful and wanton or whether it was reckless?
Well, first, we're arguing that call to duty terminated.
So you are arguing that the
Yes.
call to duty,
So,
okay.
but what I'm saying is that even if you concede that particular point, you should still affirm the trial court's decision with respect to immunity as a whole, because there's still an issue of fact with respect to the conduct, because even if there is an emergency call to duty, you still have to make the determination as to whether or not that conduct satisfies one of those exceptions and whether it's reckless or one with respect to either township or the officer individually as well.
He was still required to go there under the policy, right?
I don't know that that's established under the record that he was required to go there. Again,
I thought he was required to continue to show up.
Our position is that the call terminated when the individuals were in custody, and that was communicated to his MDT.
Was it a township officer who was involved in the?
I don't recall who was involved on the underlying call.
I mean, you are aware that Ohio has really expanded the call to duty.
I understand.
I mean, it's just elastic at this point.
I understand.
I mean, we have a case where officers were engaged in a memorial service in Fountain Square. You're familiar with that case? And that was a call to duty. Yeah.
Oh, so to that particular point, we're not asking the court, we're not asking you all, well, we don't believe that it's this court's determination, make a determination on wantonness or recklessness. That is for the jury to decide. And so certainly, those are, that law and those factors and whatever the totality of the circumstances is that the defendants want to put on with respect to the jury can hear all that evidence and they can make that determination as to whether or not this conduct sufficiently satisfies the elements of the exception for the immunity statute. But
And I want to go back to something you mentioned, and it's okay if you're not familiar, I just want to know. You said that you thought that there was some expert evidence with regard to the construction zone as to, that supports that the construction zone is somehow special. Because if the construction zone is a factor in determining willful and wanton or reckless, as opposed to driving on the street, just driving on the highway, right?
yeah, and I think what I said was I'm not sure if there was any sort of engineering testimony with respect to this particular construction zone.
But was there any evidence about construction zone in general, about why construction zone is somehow different than driving in the street?
Not why the
Driving in-
construction zone specifically is different, but there's certainly a testimony and an opinion that going through its construction zone that is identified as a 25-mile-per-hour zone with other people around is dangerous. Now, as to why that's dangerous, I don't know if there's any testimony or any expert that's indicating as such. I'm not sure. Looks like I have about 4 seconds. But
So in regards to the opposition, what was the expert affidavit the main opposition to their motion, or was it just the facts themselves that present in this scenario, from the plaintiff's perspective, create the totality of circumstance that allows this to go to the jury?
It's a combination of everything. So it's not only the expert testimony, that's just a piece of it. It's everything else we've already discussed. It's the excessive speed. It's the speed in a construction zone. It's the speed with the violations of the policies. It's the speed with the maneuvering to the left, trying to navigate through traffic. It's the speed plus the general conduct of this particular officer, and it's the speed with the fact that the emergent call had terminated, and he knew or should have known that the emergency nature of that particular call had stopped because those particular people were in custody. So it's the totality of the circumstances, which includes the expert testimony as well, which is why we make the argument that there's an issue of fact for this jury to make a determination on
I
those
do have one more quick question about the facts, because after the officer loses control, he hits the median, and that causes the car to flip. Was the median pre-existing? Was that just something that was just there as part of the route, or was it something that was part of the construction zone, something that was there, that was created as part of the construction zone?
I don't recall, I believe it was pre-existing, but I don't know that was necessarily in the record with respect to whether or not it was pre-existing or not.
Or whether it was like, how they put up those
understand.
barriers, yeah.
I don't know that certainly wasn't specifically detailed in the record, and I can only speak to whether or not I believe it was pre-existing, but I don't.
Are there pictures that were submitted as to the?
They're part of the report potentially. Take a look at it.
All right. Thank you so much.
Thank you, Your Honor. Thank you.
Thank you. So just to kind of first address the presentment issue, I would suggest, and I would, the record does say it has to be attorney of record for the probate court. I mean, that's the statute. So it's not just any attorney that they think might be representing the estate. With respect to,
I want to go back to willful and wanton. Can you please present your, why it is that, your position is that it is in willful and wanton?
yes, Your Honor. So what our argument was with respect to that is that, one, it was a Code 3 response. So it was one of the higher levels of response with respect to the Springfield Township. It was a Springfield Township officer who was involved in the issue in the roadway with the suspect. So, that elicits a higher response from within its own department. The fact that it was at the time of night that it was at, the fact that there was a straight roadway, so there wasn't that many motorists out on the street, that it wasn't a windy roadway, that the way that Springfield Township is just drawn geographically, you have to go through North College Hill to get from one side of Springfield Township to another. So the incident was, in fact, in Springfield Township. He was dispatched, responding to an emergency involving his own officer after midnight on a straight roadway with not that many motorists out on Hamilton. He was going northbound on Hamilton Avenue towards Flora Avenue. And although it was 25, it was still, it was a straight road. And the other officer, counsel made, comments that the other officer slowed down. He was going still between 50 and 60 miles per hour. That was, even at 25, all officers, even a North College Hill officer, who this other officer was in the police report, was still responding at a rate of speed above and beyond the 25, marker. Now, there was a question, I believe, that was asked with respect to, are there levels with respect to the response of the policy? And there are. And both Chief Niehaus and Rick Bly testified about that in their deposition, that if it's a Code 1, you respond a certain way, a Code 2 responds a certain way, and a Code 3 responds a certain way.
So what about the fact that the policy itself seems to say, regardless of the code level, you're still charged with behaving with due regard to safety? It seems like a blanket statement that would probably apply to all codes, yes?
Yeah, and I would agree, Your Honor. They're obviously, Springfield Township is not advocating that their officers drive on a roadway without regard to the other, motorists, but they're saying.
And is there any testimony about how he was driving other than at this moment? That's a long stretch from Springfield Township through North College Hill. And is there any testimony about, how he behaved at intersections or lights, or was it just
Just what we have from the traffic crash report, which is involving Officer Wiley, that, the North College Hill officer who saw him for a brief second before the accident occurred.
And who authors the incident report?
The traffic crash report is from the Cincinnati Police Department. There is statements from witnesses, and then there are the officers who responded to the scene. Everyone responded to the scene. So Rick Bly responded, Chief Niehaus responded. So, there is information, and we have testimony from the various Springfield Township representatives who did indeed, were able to witness the aftermath of the crash with respect to that. But there's not much in the way of what Officer Unwin was doing from when he was dispatched until the accident happened, other than that brief window of time.
Is there any evidence in the record as to whether there was construction work taking place at the time of the accident?
There was not construction work, not that anyone has ever referenced, because of the time of the day, it was after midnight, so there wasn't work being done. There were no workers on the scene that have been noted by anyone with respect to this.
I have a question. Under for the police chief, it sounds like they are going with a negligent retention theory.
That's right.
Why is there not a genuine issue of material fact with regard to that issue?
Well, I don't think you can say that they recklessly maintain, because it can't be negligence against the police chief because it would be an immunity, right? He would be entitled to immunity for that. They would have to say he either recklessly, wantonly, or willfully retained him. I think one prior accident for a police officer, involved in a very huge jurisdiction like Springfield Township, and first of all, right before I think that this accident happened, is not enough to say that that was a reckless situation. I would also submit that there's testimony in the record that Chief Bly at the time didn't have ultimate hiring and retention authority. He worked for a township administrator who then worked for a board of trustees. The board of trustees was the ultimate hiring and firing authority within the township.
How long had Unwin been on the force?
It was just a couple years. He was a relatively newer officer, so he hadn't been there that long.
And prior to his actual hiring, was there any history of?
He had I think there's in the record he had maybe 2 speeding tickets prior to his hiring at Springfield Township.
And then one accident before this accident?
Correct.
Which was in the nature of speed?
It was a scenario where he was also responding to an emergency call, and he was trying to get over on Ronald Reagan Highway to turn around in a center median in order to access police officers who were on the other side of the roadway. And the allegation is, and well, obviously the positions are different of the parties, but the allegation is that he cut off a car in his attempt to get over. He wasn't speeding and ran into someone ran into him.
So a different circumstance than the circumstance that presented.
Significantly different, yes. All right, well, I think that's all my time, so I would ask that this court reverse the decision of the trial court and grant summary judgment in favor of the defendants. Thank you very much.
Thank you. Thank you both for your arguments this morning. We'll take the matter into submission and issue a timely decision. Wishing you a wonderful afternoon and a great week. And that concludes our proceedings for today.